When a DUI arrest involves a trip to the emergency room, medical records suddenly become part of the legal picture. Prosecutors build their case around your driving pattern, the officer's observations, and your chemical test result. Hospital records become relevant when a blood draw was done at the hospital, when paramedics documented your condition, or when something you said to a nurse ended up in your chart. Any of those items can land in a subpoena. Federal HIPAA rules and California's Confidentiality of Medical Information Act do protect your hospital records from casual disclosure. But a lawfully issued criminal subpoena or a court order can pierce that protection, and the hospital is generally required to comply. Here is the key point. The protection is real, but it is not automatic. You have to assert it. If no one files a motion to quash the subpoena, the records go to the prosecutor. Paramedic and EMT reports are public safety documents, and they are generally easier for a prosecutor to obtain than your private hospital chart. If a first responder noted slurred speech, an odor of alcohol, or something you said at the scene, that report can come in as evidence at both the criminal trial and the separate DMV hearing. The DMV hearing follows more relaxed evidentiary rules than criminal court, so a record that might be excluded at trial could still be used there. People speak freely in a hospital room, and that is understandable. But something like, "I only had a few drinks" or "I feel so drunk" can end up written in your chart. California's physician-patient privilege offers only limited protection in criminal prosecutions, so those statements can find their way into the prosecution's file. After a DUI arrest, be thoughtful about what you say in any setting, including the emergency room. Medical records are not only a risk. They can also be your strongest evidence. If your records show you were treated for a diabetic episode, a seizure, or a cardiac event, those documents can help explain apparent impairment that had nothing to do with alcohol. A defense built on a medical condition that mimics intoxication depends on exactly the records the prosecutor might want. Reviewing your own records before anyone else does is a critical early step. The DMV hearing request deadline is 10 days from arrest, and court dates follow quickly. If a subpoena is issued and no one objects, the hospital will comply, and the records will be in the prosecutor's file before you realize it. Request your own copy of your records from every facility that treated you. Do not sign any broad medical release form until an attorney has reviewed it. And preserve everything, because medical records are sometimes purged after a retention period expires. If your DUI arrest involved an emergency room, a paramedic response, or any medical treatment, the records from that night deserve a close look from both directions. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.